Hello, my name's Krysia Lynch and I'm Chair of AIMS Ireland. AIMS Ireland is the Association for Improvements in the Maternity Services Ireland, so it has a very similar remit and brief to AIMS UK, which you'll just have heard Beverly Beach talk about, I think, if the programme's right, ahead of me. I'm really sorry that I'm not able to be with you today, but there were a couple of unforeseen circumstances that we couldn't have counted on. And so Tuesday evening, while you're all probably at a reception and a nice meal, I'm still sitting here in Dublin and I'm just recording this for you. So what will follow is the presentation that I would have given to you should I have been with you at the moment. It's exactly the same presentation and I've narrated it in exactly the same way that I would have given it. So I hope you enjoy the presentation. Following the presentation, there's a video that AIMS Ireland produced for this particular year, 2016, which marks 100 years of the Irish Republic. There was a proclamation to the Irish Republic, which was read from the General Post Office in Dublin in 1916. And our Charter for Safe Maternity Care in Ireland is essentially based on that proclamation. I hope you all have a great day discussing human rights in childbirth, and I hope that I'll be able to be with you next time. So welcome to What's Going On in Ireland. So, no discussion of the Irish maternity services can ever take place without reference to the 8th Amendment to the Irish Constitution. It affects everybody who works within the Irish maternity services, and it affects everybody who utilises the Irish maternity services. As far as we're aware, Ireland is the only country in the world that has constitutional law telling people that when they become pregnant, they lose bodily autonomy and they lose the right to make informed decisions, to exercise informed consent and to insist on informed refusal. So Article 4.3.3, which is the amended article, states, "The state acknowledges the right to life of the unborn and with due regard to the equal right to life of the mother, guarantees in its laws to respect and, as far as practicable, by its laws to defend and vindicate that right." So that essentially means that the mother and the fetus she's carrying have equal rights. Please note that the article does not, absolutely does not, mention the word abortion. And yet, in Ireland, pretty much every discussion of the 8th Amendment relates to abortion. The 8th Amendment affects many, many, many more pregnant people who want to continue pregnancy than it ever does women who are pregnant and who wish to discontinue pregnancy. The 8th Amendment affects every pregnant person in Ireland. So, how many people does the Irish constitutional amendment actually affect? So, obviously it affects everybody who becomes pregnant in Ireland. We reckon there's about 70,000 babies born in Ireland every year, but that doesn't include stillbirths, but it does include twins, triplets and quadruplets, etc. We also know that about 3,500 people have a termination in the UK giving an Irish address. We know that about 1,200 people a year seek help from Women on Web. We know that about another 500 a year will seek a termination outside of the UK. But we also know that there's about 4,000 to 8,000 women who will actually get a termination in the UK, but who will not give an Irish address. And we also know that about 1 in 3 pregnancies ends in miscarriage or an ectopic pregnancy. So there's potentially, if we look at our figure of 70,000 people affected, there's actually potentially an extra 20,000 to that who may have issues associated with miscarriages and who are actually pregnant in Ireland as well. So that gives a grand total of, drum roll, about 103,000 people in Ireland every year are affected by the 8th Amendment to the Irish Constitution. And in addition to that, there are their families. So this is a pretty big deal as far as maternity care is concerned, and certainly as far as consent and informed refusal is concerned, because it affects a whole series of other things too. So first of all, it affects our national consent policy. So as you can see there, The wording of the national consent policy when it comes to pregnant people is quite different to the wording of consent policy which relates to non-pregnant people. So basically, if you're not pregnant, then you have full bodily autonomy and rights, all sorts of rights to refuse and to consent to treatment within the Irish healthcare service. However, if on the other hand you're a pregnant person, which usually means that you're a woman, then you don't have those rights because of the Eighth Amendment. In terms of the National Maternity Strategy, which was just announced and technically is being implemented now, although that's another massive can of worms that we won't be talking about today. But this is our strategy, our vision for the future of maternity care in Ireland. It'll run for the next 10 years. And within the maternity strategy, again, it is very carefully worded that it is not necessarily always the case that you have to consider or comply with a woman's desire to have or to not have particular types of treatments, procedures, or processes within the Irish maternity services. And what does this mean for women? Well, this means that all sorts of things can be carried out without your consent. They include a definition of your due date. You have no right to say when your due date is. It's actually when your medical team tell you it is. You may not have the right to choose whether or to be or whether not to be induced. You may be given a sweep without any kind of consent because your medical team may think it's a good idea. You may be subject to active management, artificial rupture of membranes, the use of CTG, the use of syntocinon, without really being able to refuse. And you may well be coerced into having those things happen during the birth and labour of your baby. So that's not a great situation. Ames Ireland wanted to identify, how many women are actually getting themselves into situations where they're not able to consent or where they're not able to refuse. So as part of our big survey, What Matters to You in 2014, it had approximately 3,000 respondents. We found that 67.7% of the respondents said that during labour and birth, consent was fully sought for all tests, procedures and treatments. This dropped to 52.8% of women who said that they were fully informed of the benefits, risks and potential outcomes of tests, procedures and treatments. And it fell again to pretty much just 50%. That's just half of women who were given the opportunity to make an informed refusal. So it's not often, it's only 50-50 that you're going to get the option of an informed refusal in the Irish maternity services. So I'm just going to mention a few exceptional cases that relate to informed refusal. The first is Mother A, and this was a case in Waterford General Hospital. It's reported in the media. And this was a mother who was attempting a VBAC, and she was told that she was at her due date and she was to have a second section. And she didn't give her consent, and an application was made to the High Court to force her to have a caesarean section. The woman, in quotes, consented just before the judgment was read out. The second case I'm going to refer to is the Hamilton case, and this was from Tralee in County Kerry in the southwest of Ireland. She had an artificial rupture of membranes against her wishes, and as a consequence, her baby and her were quite unwell. And the judge ruled in this case that the midwife was able to do what the midwife thought was best in these circumstances, and whether a woman wanted to or not wanted to consent to it was relatively irrelevant. The Miss Y case, you may have heard of that. That was the case of a refugee who came to Ireland having been raped in the country that she came from, and she was seeking a termination of pregnancy, and she was forced to carry her unwanted baby until the baby was viable, and then she received a caesarean section. Miss Y undertook hunger strikes, undertook everything she could to actually induce a miscarriage, but that didn't come about. So that's a very shameful episode in Irish maternity care, I think. The Miss P case was a woman who became injured during her pregnancy, and her condition was no longer compatible with her own life, but there was still a heartbeat, even though her fetus was only 17 weeks at the time, and so a High Court injunction had to be sought in order to turn off the life support machine. And meanwhile, her family and her children especially we're left with a mother who was really not in a good state and who was actively decomposing, but the switching off of the life support machine could not happen without a High Court approval. The most recent case is the Whelan case, which was in Cavan in the northeast of the country, and that was a case where a woman had vasa previa, unbeknownst to her, but she was bleeding when she came into hospital, and she begged for a caesarean section, and instead she received a forced artificial rupture of membranes, which it's believed was a contributory factor to the death of baby Connor Whelan. There are other cases which are confidential to AIMS, but they involve women who, more commonly than not, are actually either HRIC cases or women who have been denied a home birth, and they are essentially free birthing at home. They then present at a hospital with a newborn baby to get the baby checked out and to get themselves checked out. And we have certainly had cases where other children of that woman have been, or the woman's been threatened with having those children removed. We know cases where women and their newborn babies have been separated with Garda escorts on the door. There have been some pretty horrific things that have happened to women who have attempted to free birth in Ireland. So without a second thought, the Eighth Amendment has to be repealed so that women can have consent, informed consent and informed refusal in Ireland, and AIMS Ireland campaigns very actively for the repeal of the Eighth Amendment. Moving on to midwifery-led care, our midwifery-led care is limited to 2 MLUs, 3 domino services, and early transfer home services. And they're limited to very particular hospitals. There's some areas of the country, for example, the Midlands really have very, very little in terms of midwifery-led care. So access to service is very much determined by where you live. And in terms of home birth, it can really be determined by whether you have the capacity to pay or not. Our strategy has made provision for home birth services to be rolled out all the way through the country. But it's specifically stated that it does not make provision for freestanding birth centres, which is very disappointing. I'm going to try and focus on home birth in Ireland in the last couple of minutes. There are 3 pathways to home births in Ireland. There's a free service through a maternity hospital. The biggest one is the National Maternity Hospital in Dublin. The second pathway is the National Home Birth Service, and that's provided by our Health Service Executive. And then there's a fully private home birth service where women with the capacity of to pay can access an independent midwife. The numbers of home births in Ireland are about 270 per year, although it's very difficult to get an accurate figure because you actually have to look at the 3 pathways and try and add them up because they're not officially collated by the state. So what are the challenges to home birth in Ireland? There are several challenges. The first challenge, I suppose, was the implementation of the Nurses and Midwife Act in 2011, which enforced mandatory insurance and as a result of registration. So obviously all midwives in Ireland are registered, but you had to have insurance in order to carry out a home birth, which hadn't been the case up to the Nurses and Midwives Act. So that limits who can control the service, it limits who can practice, and it basically limits who can be a midwife working in the community. So then there's the Memorandum of Understanding between independent midwives and the HSE, and in that Memorandum of Understanding are lists of who the independent midwife can and cannot attend. So this has severely limited home birth for a huge number of women, and most formally for women who have had a previous caesarean section. And then there's a lack of unified support within the health service for home birth. So, for example, in the National Maternity Hospital, even though they have their own home birth service coming out of the hospital, women who are attending for booking scans and the like are told that their choice of home birth as a setting is incredibly dangerous by doctors and obstetricians and sometimes by midwives that they meet. So that is incredibly unhelpful and shows a complete lack of a seamless service. Other issues are that doctors, due to insurance issues again, can refuse to partake of antenatal and postnatal care with women. Midwives can't accompany their clients as a matter of course if they have to transfer. And today, on counting, there were only 9 self-employed community midwives or independent midwives working in the whole country, which is down from about 2 or 3 years ago. And part of the reason for that is a serious confrontational bureaucracy that we have in Ireland. So what has the HSE done to date in order to promote or otherwise home birth? Well, it's done a lot of things. I don't have enough time here to go through them all, but here's a few. It's eliminated the term independent midwife. It's removed any autonomy that the midwife might have had in the past. It's insisted on indemnity insurance, knowing that there wasn't any. It's created ridiculous exclusion criteria so that no woman is individually assessed, but the blanket criteria applied to everybody. And it requires that obstetricians, who, let's face it, are not actually experts in home birth, have to review women's notes and decide whether, yay or nay, they should progress to home birth or not. In addition, it's forbidden midwives to attend women who do not wish to transfer when they are told that they have to. So that means that women who stay at home not wanting to transfer to hospital care are basically left without any care at all. More to the point, they're also threatened, usually by potential legal proceedings if they're in early labour, potentially bringing the guards round. We know women who have had the Attorney General on the phone to them. All sorts of crazy mad things happen to try and coerce women into hospital settings. And also women who have had previous caesareans have had home birth eliminated for them as a choice. And then there is really a complete lack of acknowledgement that the woman has the right to choose the circumstances in which she becomes a parent. And that is in spite of the European Court of Human Rights ruling. So I just want to say a few words about Philomena Canning. Some of you may have seen the case in the newspapers and in the media. Philomena Canning is an independent midwife who's currently not practicing, even though she's entitled and able to practice. She attended a woman in, I think it was August of 2014, transferred the woman to hospital as per best practice, and then questions were asked about her care of the woman because the woman had a postnatal hemorrhage within the hospital. Philomena was accosted by health service executive personnel at her doorstep. Actually, on her birthday, which was the 12th of September 2014, they removed every single file that she had on all of her clients at the time, some 29 women. They removed all 29 women from her care and they suspended her insurance. This meant that at that time, Philomena couldn't practice, and it meant that all 29 women were without care. One would have thought that they would have insured alternative care first. Let's remember we try to be safe here, but they didn't do that. Several legal appearances ensued, one on the 24th of September, one on the 29th of September. Pressure was brought to bear on the government, on the media, and anybody that would listen via various campaigns that we were heavily involved with. And then finally, on the 27th of February 2015, Philomena's insurance was reinstated and she was able to resume attending mothers. However, she declined to do that. This is a photo of her with all the mothers that she couldn't attend, or some of them anyway. She declined to do that because whilst the original and initial review into her care exonerated her of any malpractice whatsoever and pronounced her an extremely safe practitioner, the systems review, which looks at the general systems in which the case occurred, is still ongoing, and Philomena quite rightly refuses to go to work in an environment where she's still under question and where her exemplary record still remains under question. However, you can never keep a good woman down. So Philomena started up Midwives for Choice, a midwifery organisation campaigning very, very actively. And I think Elizabeth Prochaska is here today, and she's also been supporting Midwives for Choice in actually educating midwives on what choice means and how to ensure that women within their care actually obtain choice, are enabled to give consent and informed refusal. So I'd just like to finish now with hopefully our Charter for a Safer Maternity Care, which is a video on YouTube. So somebody has to come and get this link working. So thanks very much for listening and have a great day.